So a bit of a word of warning. This is not the usual kind of video that I do. My name is Joe Miller, workers' compensation attorney in Virginia and North Carolina, if you don't know already. Now, this video is more for me than anyone else because I just need to get this out there. I'm usually not a complainer. I take life as it comes. You control what you can. Don't worry about the rest, right? But in Virginia workers' compensation law, specifically Virginia, we continually come up against a very, very unfair mechanism, in my opinion, which is continually abused by defense lawyers to cut injured workers off of their weekly checks. If you grew up in the US or any other democracy, right, you understand that the concept of having your rights properly adjudicated, right? So what does this mean? It means if you're arrested, charged with a crime, you're entitled to a trial. We all know the Sixth Amendment of the Constitution of the United States. You can go to, you're entitled to representation. Seventh Amendment, you're entitled to a jury trial. If you're charged with a crime, you can even go to jail while you're waiting trial, but you can bail out if you have enough money and the circumstances permit, and you don't get convicted of a crime without a trial of some kind. Okay? If somebody sues you or you sue somebody else, you're entitled to your day in court, right? Well, what if I told you that with respect to Virginia workers' compensation, in order to cut you off of your weekly benefits, even if you're under an award, all the defense lawyer has to do is file a paper with the commission, not have any sort of hearing of any kind, but on the day that paper is filed, you are cut off of your benefits. That is the way it is in Virginia. Many other states, you go to, certainly in North Carolina, you want to cut somebody off, you got to have a hearing first, right? You want to get their benefits cut off for whatever reason. You need a hearing. The Virginia Workers' Compensation Commission is responsible for creating their own rules for their procedures, for hearings, etc., and they installed a little mechanism called a claims examination. What does this mean? This means essentially a bureaucrat, not a deputy commissioner or a judge, called a claims examiner, reviews the paper that this defense lawyer files saying that you need to be cut off, okay, and the reasons that they give. And your lawyer has, if you have one, has 15 days to respond to that paper. It's formally called the Defense Application for Termination of Benefits, okay? And your lawyer or you would explain why you should not be cut off of benefits. But I can tell you that in 99% of the cases, okay, the claim examiner is going to look at that and basically just rubber stamp it and say, yeah, we think there's an issue that needs to be adjudicated, and they're going to send it off to hearing, which means you're cut off minimum 3 to 4 months, because that's how long it's going to take you to get to a hearing. All they need is what's called probable cause to send the matter to hearing, meaning there's just enough there's some kind of argument, if they call it a prima facie case, is made out that there's something to argue about, and so it needs to go to hearing for a commissioner to decide, and that's what's going to happen. And what that means, again, you've got about 3 or 4 months to get to a hearing, and in the meantime, your income from workers' comp, your weekly checks are down to 0. And unfortunately, the Supreme Court of Virginia has ruled on this and said this is perfectly constitutional because they have this little procedure in place, and that's considered due process. So my fellow Virginians, until the Workers' Compensation Commission changes those rules, or the legislature puts pressure on them to change that particular rule, this is how it is. Sometimes it's legitimate. The doctor returns you to full duty, for instance. You got a full duty work note from the doctor that says you're entitled to full duty, and sometimes they'll just go ahead and file one of these applications, to cut you off. And we'll go ahead and say, hey, we don't have to go to a hearing on this. Let's go ahead and agree. Yes, you return to full duty. What are some other examples of how this can happen? Let's say you're required to go to an independent medical examination. They want you to go to their defense doctor. And this defense doctor says in his or her report that contrary to what your treating doc says, there's nothing that's wrong with you now. Anything that is wrong with you has nothing to do with the accident, and you are fully capable of returning to full duty. Now, your authorized doctor has not said that, but that might be enough to create an issue that the commission has to decide, so they file this paper to cut you off. Bam, you're heading for hearing, you're cut off for at least 3 or 4 months. Now, we may win that issue eventually because typically the commission will listen to the authorized treating physician, probably 90% of the time over any other doctor. that's saying something like that. But you're going to have to get to a hearing first to have that dealt with. Let's say you've been in vocational rehabilitation and you've missed a few meetings. Okay, and I've dealt with this in the context of that video. If you ever want to watch the video on vocational rehabilitation professionals, I encourage you to watch that. We get into this. But let's say you've missed a few meetings, family emergencies, you forgot, what have you, and maybe over time of the course of the last 6 months or so, you might have missed a few of the job leads that she gave you, just never got to applying for those jobs. All of a sudden, bam, one day that vocational rehabilitation expert comes out with a report. And she documents all the times that you've missed your meetings and documents all the times that you have failed to apply for the job leads that she has given you. And she then concludes that you are therefore failing to comply with the vocational rehabilitation plan. That paper is then used that day by defense counsel in an application to terminate, and you are cut off as of that day. Now, maybe you'll win later on, maybe you can fix it, but in the meantime, it's going to go to hearing. The claims examiner is going to look at that and say, yeah, bam, rubber stamp it, and it's going to head on to hearing. And over the next 3 or 4 months, you will get no checks. So you don't want to miss those meetings, maybe. Okay, so that's a cautionary tale, which I get into in the voc rehab video also. So let's give another example. Your doctor has recommended a surgical procedure, okay? And the surgeon says that in order to do this procedure, which is going to help you get back to work, hopefully, and rehabilitate yourself, you need to quit smoking. And you need to stay quit for about 6 weeks. Seen this before, by the way. You need to stay quit for about 6 weeks, and then thereafter, you also need to stay quit during the healing period to maximize your healing and the bones fusing and what have you. And the doctor's not going to cut on you or operate on you unless you do what he says. And you tell the doctor to stick it. And I'm not going to quit smoking, and that's BS, and I'm not going to do that. And next thing you know, as soon as the defense lawyer gets that paper, because the doctor goes ahead and puts it in his notes that you refuse to stop smoking, told him to stick it, as soon as that office note lands in the hands of the defense attorney, they are going to file an application to terminate because you have, quote unquote, refused medical treatment, okay? And your benefits will be cut off unless and until you can correct that situation. But in the meantime, you know, you're probably going to have to go to hearing, and you're not going to get any benefits in advance of hearing. So one more example, okay? You're under an award for temporary partial disability. You're at a lower paying job at your employer, and because they're accommodating you and they're having you do some light duty work, okay? And since you've been back, see this all the time, by the way, since you've been back on light duty at your employer and they're accommodating you, they've been treating you like a piece of dirt. Your boss is harassing you every day. They're making you do the worst stuff. It's all within your restrictions, but it's the worst, most boring stuff you've ever done. And one day you show up and you just can't take it anymore. And you tell your boss to, you know, colorful language. You use your imagination. And your boss says, okay, you're fired for insubordination. Okay? So that means you are fired from that light duty job for cause. If that happens, okay, they will file an application immediately. You will be cut off of your benefits. Why? Because you have, quote unquote, refused light duty work. That's the way it's called. That's the technical term, is you've refused light duty work because you've been terminated for cause. And I will tell you right now that is something you cannot come back from. You will be forever barred from obtaining any workers' compensation benefits unless your doctor takes you 100% out of work due to your injuries at some point in the next 24 months from that point. I always warn my clients, when you go back to work on light duty, be real careful. They're going to be after you. They're not going to be treating you right many times. Not always, but many times that's what happens. And so you want to be on your P's and Q's and you just have to suck it up and realize that this is a temporary thing. Hopefully we'll be able to get your case settled at some point and you can get out of that situation. You may eventually win those issues at hearing, some of them. But in the meantime, you're going to be stuck for 3 or 4 months with no income. There is a mechanism by which you can speed up potentially your hearing date. You know, if you're sent to the docket, as they call it, a request for an expedited hearing. It's under Rule 2.3 of the Virginia Workers' Compensation Commission, and it allows you to ask for an expedited hearing under certain circumstances. This is not available, by the way, to people who have never been under an award. In other words, you're filing your claim, they denied your claim. You can't get it, you can't really get an expedited hearing. It has to be a claim that's already been previously awarded to you, and now you've been cut off. Okay? So what do you have to do to get an expedited hearing? Basically, you have to show what they term in their severe economic hardship by the fact that you've been cut off of your benefits. So basically you have to show, look, I got no other sources of income. If you have dependents that are relying on you for the workers' compensation checks you get every week, and this is their primary source of financial support, that's important to know. You can tell the commission about that. If you've got any notices of imminent or threatened foreclosure, either on your house or you're going to take your vehicle from you so that you can't get to your medical appointments and things like that, or potential future employment, that's important to know. Anything relating to your immediate ability to provide food or clothing or shelter for your family, that's what you need to show to get an expedited hearing with the commission, and hopefully they will grant it to you. Doesn't mean you get a hearing next week, but hopefully it'll be moved up significantly. Bottom line, I hate to be a bearer of doom and gloom. That was not my intention in this video. But that's the state of the law in Virginia, and I think it's important that you know what to expect if you're in a workers' comp claim and what to watch out for, and that these things can come at you, when you don't expect it. And in my opinion, this unfair procedure created by the Virginia Workers' Compensation Commission to cut you off first and ask questions later is patently unfair and needs to be changed by the Virginia Workers' Compensation Commission. If you don't like it either, I encourage you to let your local state representative in Virginia know that you've heard about this and you don't like it and you think it's very unfair, especially if you have folks that are, loved ones, people that are close to you that are working in jobs that are, pretty dangerous, have the potential for injury, like construction, roofing, things like that. Because, hey, you're going to get into serious injury and this can happen to you. How could we survive if, all of a sudden he gets cut off because of some silly thing like this? We did some videos having to do with COVID and first responders and people like that who deal with COVID getting their benefits very much easier under the law. I'd like to think that we had at least some small effect by putting out those videos and yelling and screaming about that. I'm hoping that maybe we can put this out there and you get people yelling and screaming about this because it's very unfair. You should be entitled to a full hearing, just like in North Carolina, that's how it is. You don't get your benefits cut off without a hearing. If you are a loved one or under an ongoing award, don't fall asleep. Watch out for these things. If you're in voc rehab, stay compliant. If you're going back to a light duty job, and whether they're paying you less or they're paying you the same, whatever it is, if it's a light duty job, there's a good chance they're going to be after you to cut you off, and they're going to try to get you to be insubordinate, to screw up and do something where they can fire you for cause. Because if that happens, boom, you are nipped in the bud as far as your claim is concerned. My encouragement to you to let's all see if we can do something about getting this law changed, getting these procedures changed, so that people can have fair access to a hearing, not get cut off before a hearing if their workers' compensation benefits are challenged by the defense attorneys. Because right now, in my opinion, this thing is being abused. I'm Joe Miller, workers' compensation attorney. If you or a loved one have been injured, you have questions about this or any other aspect of workers' compensation law in Virginia or North Carolina, please don't hesitate to call us here at Joe Miller Law, number on the screen. And happy to talk to you. Have a blessed day. Joe Miller out.